statements of Mr. Rushdie and Mr. Reese. We can speak at length about the various injuries that each of them suffered and the trauma that has resulted and will continue for the rest of their lives. Your Honor is aware of that. Let me ask you a separate question. Yeah, and I'm going to ask it rhetorically for you to consider, Judge. What's the most horrific thing in your life that you have ever witnessed? Because what I want this court to consider when weighing potential mitigation issues that may be raised by the defense, and I see three possibilities based upon the PSI, based upon some of the conversations that we have all had together, and the separate sentencing memorandum that the defense submitted to the court. One is the defendant's age, relatively young, but he's 27 years old. I don't think that that's sufficient. The other is the lack of criminal record, which I think is an area that Your Honor has thought about quite a bit. And the third is the concepts that were presented to the court in the defense's sentencing memorandum about Mr. Matar's upbringing and the difficulties and challenges that he had as a result of perhaps a poor relationship with his dad and having to relocate from the state of California to New Jersey, and relationships with his mother and his grandmother, his failure and difficulties to fit in and to.
I'm aware.
Right. And I think that those don't hit very high in the people's view. Here's what I've asked this court to consider that the court may not have considered. The victims are not limited to Mr. Reese and Mr. Rushdie. There were over 1,400 witnesses to this event, Judge. And I would say to this court that each and every one of those individuals will live with the trauma of having witnessed this event before their eyes. And I ask Your Honor to take that into consideration and weigh that against the mitigating factors that the defense would present.
Let me say this, Mr. Schmidt. I'm certainly aware of the venue and the event and the place that it took place, and having heard the testimony of the trial, aware of what that place represents, and I think that's a factor that certainly the court should know. Do you agree with that? And the people that saw it.
And that's what we're asking Your Honor to do that. And when Your Honor views that, I want Your Honor to take into consideration Your Honor's own experiences in life, as we all take life experiences into consideration. We have to account for those and consider what these individuals who witnessed this event live experienced, or those that were watching remotely experienced and will experience for the rest of their lives.
Can I ask you one other? I just want to clear up one question that I have for you, because I've done some research this morning on this. I would note that both victims are requesting that I run time consecutively. And my review of the applicable law does not allow me to do that.
I would agree with that, but I think that that's another area that urges this court to sentence Mr. Matar to the maximum time.
Well,
unfortunately,
I just want to be clear that because of the nature of the conviction, especially in regard to the assault, which I would refer to as a felony assault, it's tied in the mens rea for that crime is tied into the attempted murder, which by law prevents me from running a consecutive.
I would suggest to this court respectfully that you should look at it, that we recognize that in order to prove and get a conviction on the assault second, we had to have had a conviction on the attempted murder under the nature of the charge that was indicted by our grand jury,
right.
Subdivision 6 of the statute.
Sure.
However, we can still look at the facts here, and we can recognize that we had two separate victims, and in some respects, two separate events, Judge. You watched the video. We had Mr. Rushdie, who went down, and the commission of the attempted murder in the second degree was completed when the crowd took down Mr. Matar, was holding him, and during the immediate flight therefrom, quoting from the statute, from the commission of the attempted murder, the assault second was committed. Two separate.
No, I understand. But by law, I have to run concurrently. I mean, you did not charge, or nor was Mr. Matar convicted of an independent, intentional assault against Mr. Reese.
The grand jury did not indict Mr. Matar on that. However, and I'm moving beyond the question. I agree
Well,
with you.
okay, you agree with me.
It's a settled issue.
Okay.
I don't think in good faith I could argue
But
with
you
the
think
second
that
time.
that should be weighed when I'm considering what sentence I impose?
Yes.
Okay, I understand.
And I would say, since Your Honor is aware of all the issues that I'm raising, consider for a moment the venue since you brought it up. And consider for a moment the subject matter of this intellectual discussion that was taking place when Mr. Matar chose to conduct his attack upon Mr. Rushdie. Now that's important for this court to consider because this court and this prosecutor, we sit in Chautauqua County, which for over 100 years has hosted the Chautauqua Institution, which in turn draws from outside of our community. The cultural fabric of Chautauqua County, the economy of Chautauqua County relies and is interwoven with the institution. So when Mr. Matar, who controlled every bit of the circumstances here, chose his victim, chose his timing, chose the venue, chose to travel from the state of New Jersey across the Hudson River into the Port Authority in Manhattan, and then take a bus across the state to Buffalo, then take an Uber or a Lyft into Chautauqua County. He chose this. He designed this attack so that he can inflict the most amount of damage, not just upon Mr. Rushdie, but upon this entire community, upon 1,400 people that were there to watch it. Consider for a moment the premeditation that took place here. Consider all of the sentences Your Honor has given to other offenders, and consider those circumstances where there is some interaction with outside forces that create the circumstances by which crimes are committed. How many times have we seen somebody who, by their own volition, based upon their value system, have made the choice, a premeditated choice, to attack somebody without provocation based upon his own belief system? And in considering that, consider the immediate flight therefrom that occurred here, because this is very important when you consider what to do with Mr. Matar. Mr. Matar recognized, and I think it's reasonable for me to argue, that Mr. Matar recognized, given his selection of this venue and the timing of this, where there were so many people around, that he was going to make his attempt, and he knew that he was going to be either taken into custody or perhaps injured or killed during the commission of this act. And yet, that didn't prevent him from committing his act. We're a society of laws. It's just the rule of law that prevents me from acting upon my own inclinations, Your Honor as well. And without those, what happens? We have pure anarchy, and we react to a violent, we just go through with our violent impulses. This individual had days to determine what he was going to do, days to reconsider what he was doing. He may have had months. That's outside the evidence. But he had enough time to consider all of these circumstances, including the end result of his acts for himself, and that did not prevent him from coming into our county and committing these acts at the Chautauqua Institution. And Judge, going back to those 1,400 people, which may be watching this from a deterrent standpoint or from a punishment standpoint, just consider for them the venue and the nature of it. And I know Your Honor has taken that into consideration. Consider the last time Your Honor might have gone to, let's say, a concert or something. We somehow mentally prepare ourselves when we go to certain events. There may be jostling. There may be some physicality approach. Do I have reserved seating? Is it standing room only? There may be something, and in some respects, each and every one of us, when we go out into the world and we interact with the world, we prepare ourselves mentally for what may or may not occur. This was a venue that was, and the testimony was very clear that what was on stage was discussions about freedom of expression, about concepts related to home and the safety of home, and how Mr. Reese and the City of Asylum entities across the world have provided refuge for persecuted writers and artists who, based upon their expressions, their creative writings and expressions, have been persecuted, have lost their homes, their livelihoods, have suffered financial, physical impacts. That is the venue that Mr. Matar chose for his attack happened. And based upon that, Your Honor, I urge this court to sentence Mr. Matar to the maximum sentence. Thank you.
Thank you. Mr. Barone, anything on that prior to the imposition of sentence?
Well, Judge, I guess my understanding of justice is different than what Mr. Schmidt says. But I suppose that when Mr. Schmidt reaches for these conclusions about what Mr. Matar's own beliefs were or what his intentions were, there's no proof whatsoever as to what they may have been at the time of this incident. There's no proof, no evidence, no testimony as to what Mr. Matar knew or what he didn't know about the event that particular day. Nothing. There's no evidence, either by testimony or any other form, that he planned to victimize 1,400 people that Mr. Schmidt is looking to include as victims in this case. There's no denial that there are victims, and that's Mr. Reese and Mr. Rushdie. And I find it somewhat ironic that Mr. Schmidt talks about freedom of expression, freedom to do what they want to do or what's necessarily needs to be done. And at the same time, Mr. Rushdie, in his statement as a victim in this matter, talks about Mr. Matar's political gaze and or his behavior or his religion or whatever it may be. Because if I'm not mistaken, at no time during the trial was there any testimony, was there any evidence submitted that in fact referred to motive for this incident and or intent. Anything that was drawn by that jury was done circumstantially, but there was nothing else to even draw a reference as to what Mr. Matar knew or what he didn't know, what he intended on doing or what he didn't intend on doing. So I think that's a real reach on the part of the prosecution in asking the court to consider that. As a matter of fact, Mr. Reese was cross-examined by Mr. Williams during his testimony. And I believe that Mr. Reese referenced in a question posed by Mr. Williams about the injury he received, specifically the cut to the eye area or the face. And Mr. Williams asked him, could it have been a punch or from another individual? And Mr. Reese agreed. He had no specific information that it was either Mr. Matar or a knife that caused that injury. So, and in regard to that, Judge, again, the conclusion reached by Mr. Schmidt as to who these other victims are, I would just suggest to the court, most importantly, and I would like to believe that this should be seen as any other case, and I do agree with the prosecution. This case,
let me ask you this, Mr. Brown, just going to ask, because you talk about, and I agree, there was little to no information during the trial regarding why this was committed, but inherently in that is sometimes I look for reasons. Most of the time, you can glean just based upon the evidence that's presented here at trial or at the trial why people are motivated to commit intentional crimes and the underlying reasons therefore. So if you say that was absent, there was evidence to suggest that Mr. Matar came from out of state, he came to the Chicago institution, he was prepared to carry out this act, and it would suggest to me, and he was found guilty of an intentional act, and it begs the question for the court. And it's hard for me to mitigate that when he comes to a venue, and clearly I have to take into that it's a venue, that there are, as Mr. Smith said, hundreds, if not 1,000 people in attendance, that this is the venue that Mr. Matar chose to come to. And so it begs the question, why? And I have to take that into consideration.
Well,
I can't just say this is, for example, a boyfriend and a girlfriend, and the boyfriend gets mad because the girlfriend did something, and those are relatively simpler sort of situations where most times people have motive because something is occurring in their lives that upset them, right?
well, sure, but at the same time, if the court's going to do that, then you have to take into consideration any other factors, quite frankly, because there's no evidence or testimony or any indication of why he actually came to Chautauqua that day. And you can draw all the conclusions you want from the circumstantial evidence, but again, that requires the court to bring into consideration any other possible factors of why he showed up at Chautauqua that particular day. Could it have been perhaps because he looked up Mr. Rushdie's speaking schedule and just saw, hey, this is close to where I live? That's certainly a reasonable possibility, isn't it? Just as reasonable as what Mr. Schmidt suggested to the court. And the other thing, which I would object to strenuously, even to be considered by the court, are these other 1,400 individuals Mr. Schmidt references as being victims. There is no evidence that they were traumatized, victimized, or anything else. And to ask the court to take that into consideration is beyond the scope of any reasonable determination by any reasonable court in determining what justice is in this case. And I don't think that it should be. I think that's way out of line, Judge. So if you're going to consider these other possibilities, well then, okay, but consider everything, not just one-sided possibilities, but you're going to have to really start stretching the imagination. And to do that's improper. You're looking at what was submitted, what was admitted, and what was referenced at the time of trial. And there's no reference to that. And to do it now is, I'd say, Judge, beyond what our system is intended to do. And that's provide justice. And that's to take into consideration this young man, the mitigating factors, and what may or may not have happened to the two victims in this case, Mr. Rushdie and Mr. Reese. They've submitted statements, they've submitted what they're looking for or what they're not looking for. And I would just suggest to the court, I would hope that our society's come a little bit further than just getting a conviction against someone, locking them up, throwing away the key, and forgetting about them. I would hope we're not that archaic anymore. I would hope our courts want to look at an individual as a human being, regardless of what they've done, and consider every holistic approach. But if we're going to do what Mr. Schmidt wants the court to do, just lock them up, well then why even consider any mitigating factors? Why consider everything that's been enacted by our criminal justice system that the court is required to take into consideration? And that's everything that we submitted in that sentencing memorandum.
But I would also suggest to you, Mr. Barone, Mr. Matar doesn't give a statement during the pre-sentence investigation report.
Well,
I can't, hold on, let me finish.
Sure.
So it's hard for me to take into consideration litigation if he refuses to give any sort of response during the pre-sentence investigation report. How do I know that? How do I know why I should mitigate it if he's not going to say anything about it?
Well, Judge, I think there's a couple answers to that. The first is, unfortunately, we're in a catch-22, and I don't think this is that unusual, but the court's certainly aware of this, and Mr. Schmidt is, that there's pending federal matters involving Mr. Matar. So,
Well, I don't think that they would be allowed to use anything that he said in the pre-sentence investigation report, Mr. Barone. I think they would be precluded from gathering that information using
I disagree, Judge, and not necessarily. Absolutely not. It could be used. What if Mr. Matar chose to testify at a subsequent federal trial? If he does, then that certainly could come into evidence as impeachment information. We use PSIs all the time, or we are able to use those for impeachment purposes on cross-examination, or for other situations, or perhaps the probation officer is subpoenaed in for subsequent hearing or trial or administrative proceeding. So there's a number of situations that could arise that would create difficulties for Mr. Matar.
Let me ask you this, Mr. Barone. On behalf of Mr. Matar, what would you advocate? I mean, clearly these are Class B violent felony and Class D violent felony. It requires the imposition of a state prison term, and I think Mr. Schmidt has already acknowledged the fact that they need to be run concurrently. What would you recommend?
As far as the sentence?
Sure. I mean, you're advocating on behalf of Mr. Matar.
Well, Your Honor, that's a good question. And I suppose that's something that I would certainly, I think, you want an answer to that?
Well, I mean, you don't have to.
Well, no, I'll give you an answer. I'm asking if the court wants an answer. Because I do have an answer. I think the first thing I do is understand what's happening in this courtroom, what's happening in this case. And I think it goes back to when the incident occurred. Immediately after the incident, and when I say immediately, I can't reference the exact time frame, but it was within a week or two. The publicity that shined on this particular incident can't be denied. I think Mr. Schmidt would agree with that. I think the court would agree with that. The press had Mr. Matar tried and convicted soon after this happened. Every day since then, for the last couple of years, this case has been an international publicity sponge, and everything that's occurred has gone against every constitutional right Mr. Matar may have been protected by. Maybe not intentionally, I'm not saying that. Maybe unintentionally, but the truth of the matter is there was no presumption ever of innocence for Mr. Matar from the very beginning. And again, I'm not pointing fingers. I'm saying that's the reality, regardless of what anyone wanted. It doesn't matter. The truth of the matter is, if we're going to be transparent and talk about this, let's talk about it. And the fact is that Mr. Matar was guilty from day one, according to society. And then it became an issue of who the victim was. This victim wasn't just some other individual living in Chautauqua County. Perhaps someone who was unemployed. Perhaps someone who was working at a minimum wage job here in Chautauqua County. Or perhaps a minority here in Chautauqua County. Or perhaps someone with emotional disorders or problems here in Chautauqua County. Or perhaps someone with mental health issues or addiction issues. That's not the victim in this case. The victim in this case is an internationally known author, Mr. Rushdie.
Doesn't that go against Mr. Matar as well? I mean, if you talk about the fact that Mr. Schmidt presented no evidence at trial as to why Mr. Matar travels here from New Jersey to commit this act, but the evidence suggests that he does, and there is evidence at trial that indicates that Mr. Rushdie is an internationally known author, that he's written all these books, and, you know, as a court, I can't stick my head in the sand and say, well, Mr. Schmidt didn't indicate why he necessarily did it, but certainly the court needs to recognize that because it was committed against someone who is a high-profile international author, and that he testified regarding that, that I can infer from that that part of the reason he did it was because of his vocation, correct, and his high-profile status.
I agree with that.
All right.
I agree. It's a double-edged sword.
Sure.
And I don't disagree with what the court's talking about. But again, I think that Mr. Rushdie and his status in society certainly determined from the very beginning what accommodations were made for Mr. Rushdie that typically would not have been granted to any other Chautauqua County resident, quite frankly, unless there were unusual circumstances. And I think that, unfortunately, the status of Mr. Rushdie drove this case or kind of steered the ship, so to say, in a lot of ways. And I think, which was a very difficult case to begin with. And the court certainly, when you talk about not sticking your head in the sand, is certainly aware of the fact that these are difficult cases for any defendant. Anyone accused of a crime has an uphill battle. But when you take a young man, a Muslim in Chautauqua County who's from the New York City metro area, and you have an alleged victim in Mr. Rushdie, an international known author, and you have someone of Middle Eastern descent, and then there's the publicity that was out there prior to trial. Our battle was from a number of different fronts. It wasn't just the front with the prosecution or with the court. You have a number of different factors that you had to take into consideration. And even dealing with the press and one of the press individuals getting access to Mr. Matar at the jail. So you've got then the 20s at the time, I believe, and I apologize, Mr. Matar at the time of the incident was 24. And so you've got a 24-year-old male, and we've submitted in the sentencing memorandum a number of different issues that we've asked the court to look at. And unfortunately, there's a lot of people in society that aren't born with the benefits that we would hope everyone has. The simple benefit of having a family that you can be safe in and protected in and given the right guidance and given the right support. And if the court reviews that sentencing memorandum, you'll see that the issues facing Hadi Matar, who was born in California, who had no other desire than to be an American citizen, and at a time when 9/11 just occurred, and Hadi trying to assimilate into the American society, even with the name Hadi, and with poverty being a huge issue with Mr. Matar, and everything else we've referenced, you get into a situation that you're asking someone like Mr. Matar be able to dissect what he can talk to the probation officer about and what he can't in that jail. And the court knows it better than me. The first wrong thing he says, or just making reference to something that can be taken and twisted a certain way, is going to come back to bite him in the ass. And everybody knows that. I mean, really, to expect this young man, who has every constitutional right to remain silent, is going to be now penalized because he didn't say something during his PSI?
No, but I listened to Mr. Murray. He doesn't have to. He doesn't have to address the court today if he doesn't wish to. But if you're requesting that I somehow mitigate what has gone on here, given the evidence of trial, he's been convicted of this. We're at the additional stage that, and again, if you're requesting mitigation, then I need to know what the mitigation is. I had an opportunity to review your pre-sentence memorandum for him, and I obviously looked at the pre-sentence investigation. And I agree that there was little information provided in court that would establish the motivation as to why he traveled from New Jersey up here and committed this act. But it doesn't negate the fact that he's done that. And I need to take into consideration, I don't want to grasp at straws. I don't want to be unfair to the people of the state of New York, and I certainly don't want to be unfair to Mr. Matar. And so I'm just looking for as much information as I can so I can impose the appropriate sentence in this matter. And I do have questions. I do have concerns about the nature of this and the fact that it occurred at the Chicago institution and that it occurred at a public event and that Mr. Rushdie, who's a worldwide known author, was there to give a speech and talk to this crowd. And it was at a venue that, in my opinion, espouses the freedoms that we're all entitled to, including freedom of speech. And, is there more information around attempting to prevent that? And I think that those are factors that I need to take into consideration. So the more information I can have either from the district attorney's office herself or Mr. Matar certainly would help me understand that. And I think to myself that although there wasn't a lot of evidence presented at trial, like I already noted, picking a public event, picking a location where there were going to be people present, and picking an event where there was talk about not suppressing freedom of speech are factors that I need to consider. Because it goes to the very heart of where our country stands for. And I'm not going to say that Mr. Matar, who is as you've indicated, is a United States citizen himself, certainly has the right to exercise his free speech if he wishes to. And he can speak out against Mr. Rushdie all he wants if that's what he wishes to do. But I draw the line where it now becomes at least partially evident, in my opinion, just based upon the facts and the evidence presented at the trial, that he was attempting to prevent Mr. Rushdie from exercising his.
No, I understand, Judge, and I would just add that the PSI indicated there was two law enforcement statements that were provided by Trooper Nagle. I apologize, I can't remember the second, but they both indicated that Mr. Matar, after being taken in, or was cooperative at the scene of the incident when he was taken into custody. And I think Trooper Nagle went on to indicate that Mr. Matar didn't say anything, or he was quiet about things. But he was cooperative.
I understand that too, but I just have to mention, I'll let you be heard. And I understand that, for example, almost every day that we held court proceedings in this matter, and it was outside the presence of the jury, but I was in the courtroom, Mr. Matar would be brought in, and he was, and I'm not talking about what he said, I'm not going to repeat it, but he would say things that obviously he wanted to express himself regarding what he felt he believed in. I never stopped him.
No.
Right? And so just, and he has the right to say that and think that. But, you know, if this somehow dovetails into what he believes his motivation is to travel from New Jersey and come up here and commit this act, I'm not meaning to say that he can't exercise his right to free speech, but he shouldn't be preventing someone else from preventing their right to free speech by committing an act of violence.
I understand, Judge, what you're saying. I think that any references that Mr. Matar made in the courtroom, and I do know that the PSI addressed this to some extent regarding Mr. Matar's religious beliefs. And I think that the PSI report referenced two or three, and I apologize if I'm wrong, 2 or 3 separate events that occurred at the jail. And I do know that it was the discussion the probation officer had in the PSI report about 2 of the 3 was somewhat limited. However, I will point out that on one of those incidents, and the court may recall this, that when COs reviewed and what I found a little bit disturbing, I believe that this last incident was actually during trial. Mr. Matar was the victim of an assault at the jail and was caught on video. And I believe the COs indicated that there were at least 50 punches and kicks to Mr. Matar's head and his body. At which time, at no time, did he in any way fight back, raise his fist, do anything other than take a protected position for himself. That's a little outrageous. There's no other indication of Mr. Matar doing anything that during this particular attack, and when asked about certain things that occurred, he told the probation officer that he believes very strongly in his religious beliefs.
And I have nothing against that.
No,
I tried to make accommodations for him during the trial when I could, and I would indicate at the same time that I'm speaking about the right of freedom of speech. There's also the right to freedom of religion that is protected under the United States Constitution, and that includes every religion, in my opinion. And Mr. Matar is entitled to his beliefs in that regard, and I respect that, and try to recognize that and afford him the opportunity to exercise his religion during the trial.
Let me just move ahead quickly, Judge, because I do want to answer your question. And I think that when you take these particular situations, the court is in the difficult position of determining what justice is in this case. And I think all of us that work in this system would agree that that justice itself is not always easily obtained. And there are mistakes made like anything else. And justice is a case-by-case basis. And I think, again, everyone would agree. And it depends on the situation. And I think that when we look back over the last couple of years regarding this particular case, and again, I understand the court would probably be helped to some extent, at the very least, if Mr. Matar had talked about certain things. But again, I would hope that the court appreciates that, as counsel to Mr. Matar, we've advised him as well. Listen, you can't talk to anybody about anything, and you have to be very careful. But at the same time, Judge, when we were discussing this case during several pretrial conferences, and we come in and we have hearings and we get together and, and maybe society and the public isn't aware of this, but there'd be discussions about everything that Mr. Schmidt talked about, most notably Mr. Matar's lack of any prior criminal history. The court's aware he's never even been arrested. He's never had any problems. No matter where he's gone, he's got an absolutely clean record. But that being said, we discussed what would be an appropriate resolution to this case. And obviously, I've had cases. I'm privy, or I know of cases, where in this court, there's been other cases involving attempted murders, or assaults, murders, every kind of case you can think about. And, I do appreciate that every case is different. Just because something happens in one particular case as far as a sentence goes or a resolution doesn't mean that any other individual is entitled to the same benefit or the same punishment. This is beyond punishment. This isn't just about punishment. This is about an individual, looking at an individual and taking him as a whole and dealing with the situation. And I would suggest just to punish him to the maximum of 25-year determinant is harsh and excessive, especially when you've had, or we have had, individuals that have been arrested on murder charges, come into this courtroom, plead to a lesser charge of manslaughter, and because they went up to another individual in this county and shot him at point-blank range in the chest and killed him, and he's getting 10 years.
Listen, Mr. Rowan, it's a case-by-case basis. You know that.
I understand.
I'm not going to
I understand.
rehash in particular other cases. So what do you advocate?
So, I'm saying, Judge, in our case, we had discussions as to what would be an appropriate resolution. Mr. Schmidt made or discussed with a plea to the charge what a possible cap, or the court discussed what a possible cap could be. And there were discussions of a cap by the court of 20-year determinant, or we even discussed, the defense discussed 18 years, 15 years. All those discussions were had. So we would suggest in this particular case, given his history, given the lack of history, given the environment that Mr. Matar was raised in, what he had to deal with, and look, we all know that you don't get to a certain age, regardless of what that age is, but especially when you're 24 years old. The science is undisputed. They're not a young male at 24. Who had issues with during his formidable years of being raised can't even sometimes make rational decisions. But beyond that, Judge, we would suggest, based on all of that, an appropriate sentence would be a determinant of 12 years.
Thank you. Mr. Matar, please stand for me.
Excuse me, one second.
Go ahead.
again, and I'm saying that as a risk to my own life by saying that, but I should say it anyways because I feel that that's important. That was an individual who, even though his life was in danger by speaking out against Israel, Salman Rushdie, and I don't even like mentioning him in the same sentence, but Salman Rushdie lived a very comfortable life in that head. He wasn't really prosecuted. Even in the United Kingdom, he lived a very comfortable life. Sayyid lived a very hard life. He had to live in hiding because he was under threat by Israel attacks, Israel bombardments, just like Palestinian people. I think those protesters, Sayyid, those people, those are real heroes of freedom of speech. And Sayyid Nasrallah died for that freedom of speech. And so I think that's a hero of freedom of speech. I believe in freedom of speech, but I believe respect and respecting others is also important, and we should have a culture of respect. I think you could have both a culture of respect and free speech. That's all I wanted to say.
The appropriate sentence in this case, the evidence that was presented at the trial, and what you just indicated to me on the record, Mr. Matar. I have a tendency to disagree with what you were asserting. I mean, you may not respect Mr. Rushdie's point of view or how he's lived his life, but in the United States of America, we have the right to live the life that we choose. And he has the right to express his views in the same way that you have the right to express your views. And again, I go back to the times that you walked into court and you would say things out loud, and I never made any attempt to curtail that by you. I certainly could, because it's a court of law and I don't want to be disturbed, but you obviously, just based on what you said today and what you said when you were walking into the court, have a deep-seated ideal in your head about Palestine, Israel, about the religion, and that's okay, and I respect that. You can hold those views, but in the United States, everybody's entitled to have different views and different opinions about things. And what is truly disturbing to me about this case more than anything is that your ideals, because you believe that Mr. Rushdie shouldn't be respected, justify the actions that you took at the Chautauqua Institution. Again, an institution or a facility that, in my opinion, is the epitome of freedom of speech, is the epitome of freedom of religion, which makes me then also, based upon the evidence of the trial that we've said here today, conclude that you intentionally picked this facility out and went there to make your point against Mr. Rushdie. I believe in mitigation. I believe in taking into consideration the lack of a criminal history that one individual may have. I believe in looking at someone's age when I'm rendering a sentence. But in this case, it's very difficult for me to mitigate my behavior. And I ask myself, if I gave you 12 years, or if I gave you 15 years, of course, is that a deterrent? Or does that remove you from society for a period of time, which is one of the tenets of the criminal justice system? Sure. But your just disruption of our system and me, it's not me asking why you did it, because I think I understand why you did it, just based upon all the facts and evidence and what you said here today. But then I think to myself, what prevents you from doing this again? Again, I don't disrespect your position in regard to religion or in regard to respect or disrespect, but what prevents you from getting out and attempting to do it again to Mr. Rushdie, or doing it to someone else that you think is being disrespectful to whatever your ideals are? We all have the right to have our own ideals in society. America, that has to be an answerable crime. And we need to send a message through the judiciary that it just will not be tolerated. It is the judgment of the court in regard to the attempted murder in the second degree that he be sentenced to a 25-year determined state prison term plus 5 years of post-release supervision. In regard to the assault in the second degree, it is the judgment of the court that he be sentenced to a 7-year determined state prison term plus 3 years of post-release supervision to run concurrent as is required by law. There is a $375 surcharge that goes along with this. You'll have 30 days from today to file a notice of appeal, and you'll be remanded to the New York State Department of Corrections to complete your sentence. Is there anything further, Mr. King?
No.
Mr. Barone?
Yes, sir.
Anything further?
Your Honor, just for the record, note our objection is to the sentence, and we're prepared to go ahead at this point with filing anything on behalf of Mr.
So moved.
Thank
Thank
you.
you.
All right.
Thank you.